Hi everyone, happy Monday. The sun is shining again this week after last week being so rainy. So join Jackie's on Monday mornings at 10. Next Monday's Easter Monday though, so I will apologise because I will not be doing it next Monday. This week I wanted to talk about negotiating for what you want. Newsflash, most solicitors don't actually get negotiation training. How bad is that? So we learn negotiation skills on the job, and we learn to negotiate from a rights-based perspective, which can prolong arguments. It can reinforce entrenched positions and make it harder for people to settle. Now, we hope that a lot of people resolve disputes without coming to lawyers, and that lawyers are one of the last resorts. There are more and more alternative dispute resolution processes out there. And in fact, what we're focusing on this year at TBA Law is upskilling our solicitors with a broader range of negotiation skills. So Rochelle is actually doing her mediation training at the moment. I did my collaborative practice training last year, and Sarah is going to do her collaborative practice training this year as well. So the three of us will have more skills around early stage negotiation and trying to prevent things from progressing into court. By the time things get to court, yes, the courts do require a compulsory mediation process in most court matters. By the time it gets to that stage, which is a later stage mediation, more likely it's a shuttle style mediation, and it's a mediation that's moved beyond what's called interest-based negotiations. So that is what I wanted to talk about today, is you having some negotiation skills for yourself in terms of the difference between rights-based negotiation and interest-based negotiation. Okay, so as I was saying, rights-based negotiation is where you find out your legal rights and you position yourself into, no, it's got to be this percentage, it's got to be this sort of outcome, rather than actually looking broader at your interests. Whereas an interest-based negotiation is more about, well, what is the actual outcome that I want from this? Not is what is my legal right? What do I actually want to resolve here? What relationship, if any, do I want after this dispute ends? What abilities do I want to be able to do after this is resolved? So it's more around looking at a future focus rather than a rights focus. So it's a little bit non-traditional when you think of the legal setting. However, it's not non-traditional at all when it comes to early stage negotiation, because all this research was actually done in the 80s and it's been developed over the last nearly 40 years. So when negotiating for what you want, you actually need to know what you want. So that is the basis of interest-based negotiation. What do you actually want? Not what your lawyer tells you what you should want, not what your friends say your percentage should be, not what the principle of the thing is. As I often say, principles are expensive. And then also think about your conflict style. Think about what is fueling the conflict as well, and then turn your mind to the future. So there are 5 main conflict styles, but generally you're either avoidant or competitive, or collaborative, which is sort of in between. So think about the conflict style you're coming to this dispute with, and then think about what is fueling the conflict. Is it a difference between values? Is it a difference between your needs? Are you expecting someone else to meet your needs when in fact that's probably not their role? You need to meet your needs. And so in terms of working out what your interests are, thinking, okay, how do I make sure that I can meet my needs out of this? And also, what stories are you telling yourself? What assumptions are you making? What presumptions have you made? you are putting some kind of story, no doubt, on how the other person is thinking or feeling as well, maybe without even having that conversation or asking them. And then in terms of interest-based negotiation, you then attack the problem of the dispute rather than the people themselves. So in a way, you can sort of come together as a team, these two people who are in dispute, and yes, you've both got your emotional baggage around that, but you have this problem which needs to be solved. And so you can work together on solving the problem rather than attacking each other. And keeping in mind as you go about solving the problem, how are you going to meet your each respective party's interests? And the other thing that lawyers often do in a rights-based negotiation is that they think about all the options for you without brainstorming them with you, and they rule out a whole lot of options which actually might have some validity to be able to resolve things. In an interest-based negotiation, you are brainstorming all the different options without having any judgment about the options immediately. So you don't rule anything out, get all the options up onto the board, and then start assessing them after that. So don't rule anything out early. When you rule something out early, the thing is that the thing you've ruled out might have worked in combination with something else to make the perfect outcome. So then there's probably not one perfect outcome. It might be a combination of a multiple of things. So there you go. There's some negotiation tips. I will save this video onto the Facebook page. There are over 100 other videos there as well if you go to the videos tab. Otherwise, let me know if there's any topics you specifically want me to cover. If this is relevant for anyone else, please comment and put their name in the comments, or you can share it with them via Messenger so that it's private. Otherwise, contact us, either direct message us through this page, or if you go to the website, all our personal emails are available there as well. I hope you have a great week. I hope you have a safe Easter if you are traveling, or even if you're staying home. Stay well, and I will catch you in a fortnight. Thank you.